Hello, everybody. On this Monday, April 18th, I'm Spencer Mazyck, and this is the Bloomberg Law Podcast, a series of interviews focusing on trends in the busy legal profession. Recently, Google has been involved in a series of high-profile antitrust battles. And today we want to examine if the world's largest search engine should brace for the impact of a sweeping probe of its operations by the federal government. Joining us in studio for today's discussion is Peter Greene. He's a partner at Skadden Arps who handles litigation and advisory antitrust matters. Welcome, Peter, and thank you for joining us today.
Thanks very much for asking me.
Okay, so before we get to whether a broad antitrust case is in store for Google, tell me this. Why is Google the target of so many anti-competitive claims?
Well, probably there's several reasons. Google's very, very big. It's very successful. It's very innovative. It has a product that is a little confusing to many, and it's certainly threatening to many of its competitors. It's also generated several competitor complaints and complaints from various industry focus groups and some public interest groups. That's all kind of helped the mix of getting interest in antitrust in Google. It's kind of a modern-day Microsoft, if you will.
Well, and I think one of the reasons why Google maintains its dominance is because it grows and it keeps acquiring companies. And as you know, about a week or so ago, Google won the approval from the Department of Justice to acquire for $700 million ITA software. Do we know what Google plans to do with ITA?
Well, we know what Google says it plans to do. ITA, of course, is a vertical search engine, and Google says it's going to take the technology that ITA had, couple it with its technology, and make it more efficient and easier for you and me and the rest of society to search for that best cheap airline flight one can find. That's what Google claims is their aim.
I think the idea is to be able to type into Google flights to someplace sunny and warm under $500 in May, and then not only get a set of links, but then you also get flight times, fares, and then also maybe it directs you to someplace where you can go and buy that ticket.
Precisely. You're going to get the flight times, the airfares, and you're going to get the advertising.
Okay, but this ITA deal, though, came with some very important conditions, didn't it?
Yes, it did, because when you say the government approved it, they approved it subject to a consent decree. And the consent decree tried to address the competitive concerns that the Department of Justice identified in their investigation. So under the decree, Google has to continue to support the ITA technology and continue to license it for 5 years. It has to continue to invest in it. It has to treat other competitors in this segment equally and fairly, and if they don't, it has to give to the government every objection it receives, every complaint it receives that has somehow treated those competitors unfairly.
And is there going to be some sort of, didn't they agree to a government monitoring, 5-year monitoring provision?
That's part of the monitoring provision, the reporting obligation that I just described. That's part of it. That's correct.
And it seems to me, though, that after about 13 years of operating largely free of government intervention, Google is now faced with some new regulatory realities. But let's move on. What other notable acquisitions were made by Google in the last few years?
Well, Google's engaged in a few transactions that have sparked antitrust interest. They acquired AdMob, a company called AdMob, that was an advertising
it's like a mobile
advertising service. That's correct, for telephones and things of that nature. And that created an investigation. Ultimately, it was cleared and there was not a problem found. They also acquired a company called DoubleClick, which was an ad tracking service. Again, an investigation, but there was no enforcement effort ever found.
Well, so were there conditions, though, imposed on any one of those acquisitions?
No, not by the federal government.
Okay, and I have to say that not all of Google's attempts to expand its empire have been successful. I know you can't comment on this, but I think it bears mention that Google Books suffered an antitrust setback in March when a New York federal judge rejected a settlement Google made with publishers and authors to create a massive digital library, partially because it effectively gave Google the rights to orphan and unclaimed books. But didn't Google also have to scrap a deal that it had with Yahoo back in 2008?
Yes, it did. It entered into a proposed joint venture with Yahoo where, pursuant to which it was going to give Yahoo access to one of Google's programs and therefore allow Yahoo to place on its advertisements that were generated by Google. The federal government objected to that. They threatened to sue, and Google and Yahoo walked away from the deal.
And you mentioned this a little bit a while ago, but because of Google's dominance in the marketplace, many folks have been quick to compare it to Microsoft.
Yes.
During its heyday. Is Google the new Microsoft?
Well, in terms of antitrust issues, in the broadest sense, they're similar. The same issue that obtained in Microsoft, whether Microsoft was using its size and position to somehow leverage itself anti-competitively into other markets or maintain its position in that market, is at the core of the interest about Google. But the types of issues, the specific issues, are a little different.
Okay, and before I ask you to speculate in terms of whether or not there's a U.S. federal probe coming, let's talk about what's happening outside of the United States. As I understand it, late last year, the EU launched an investigation into Google's business practices. What was the impetus for this investigation?
Well, there were several competitor complaints. The press reports that there were 3 competitor complaints, and they basically were narrower search engines that were complaining, vertical search engines, and they were claiming that Google had manipulated its rankings to their disadvantage, the rankings that come up with when you do a Google search. Since then, there have been additional complaints in Europe.
And I said it's interesting that we just compared Google to Microsoft because, as I understand it, Microsoft also added a complaint pretty recently. And what did it allege?
Yes, it did. It alleged this. Microsoft actually has 2 complaints. One of the initial 3 companies was a company called Chow, which is owned by Microsoft.
Oh, okay.
And then Microsoft recently is reported to have filed another complaint with the EC, basically claiming that Google has made it very hard or difficult for other search engines to access content, primarily access the YouTube videos on other search engines.
And what does Google's share, do you know what Google's share is of the market there in Europe?
Well, there certainly are estimates that the number of search hits are upwards of 85%, but what the market is, the definition of the market, and therefore what share you have in it, is itself a very complex question because Google competes on a variety of dimensions.
Oh, well, and I have to say that on Friday, Bloomberg News reported that there were other antitrust complaints coming out of South Korea alleging that Google is stifling competition in its domestic mobile search market. But let's bring this back to the U.S. Hasn't Texas launched its own investigation into Google's business practices?
Yes, the state attorney general in Texas has launched an investigation, according to the press, and issued a large subpoena. They call it a CID, that appears, based upon what the press has reported, to track pretty much the focus of the European investigation.
Well, and so it's kind of, is the complaint here then that Google is rigging its search results? And if that is proven to be true, would that be an abuse of its dominant position?
It could be, theoretically. It's probably one of the hardest areas to develop antitrust liability on because essentially competitors should be able to innovate. And Google's position is they adjust the ranking in order to come up with better sites for their market participants.
Better sites meaning what?
Better sites in terms of better content. So they claim there's a pro-competitive purpose. They claim it generates a better search result by their manipulation of the rankings, and the competitors, of course, claim that that's not quite the truth.
Right, and it's a better search result that just so happens not to include any of the competitors, maybe.
Well, it certainly has lowered the ranking of the competitors that have complained. Okay. That's true.
So tell me then this, though. Is the Federal Trade Commission or the Department of Justice gearing up for a probe into Google's search business?
Well, that requires a prediction, and predictions are hard, but I think it is highly likely that there will be a probe of Google's search business or the Internet search business.
Okay, and does it matter who gets the investigation, be it the FTC or the DOJ?
In some sense, it matters. How you handle the investigation will be somewhat different because of the various different structures of the 2 agencies. And, of course, some people take the position that Section 5 of the Federal Trade Commission Act, which is the law the FTC enforces, has somewhat greater flexibility than Section 2 of the Sherman Act, which is the law the Justice Department would enforce. I think that's largely, in my judgment, more theoretical than practical. I think the ultimate end result of an investigation, whether it's by the FTC or the Justice Department, is likely to be pretty much the same, but how you get from here to there could differ a little bit.
Okay, and so what's the risk to Google if these investigations prove to be fruitful?
Well, that's a very significant risk because, and I think you just pointed it out, Spencer, if the investigations prove to be fruitful, there will be more regulation, more requirements on how Google conducts its business, and that, of course, will hamper its ability and flexibility in a competitive marketplace. So it has a significant risk if the investigations prove to be fruitful.
Well, at any point, could Google be forced to disclose its algorithm? I mean, is this a real possibility?
It's a theoretical possibility. I think it's unlikely that that would be the type of remedy that one would envision. But certainly, it depends on what the facts prove in the investigation.
Okay, and in our remaining moments, I'm going to ask you if there's any sense of what Google's response have been to this threat of investigation.
Well, Google's been pretty open so far in its position. They claim that, especially with regard to their search results, they're for pro-competitive purposes. They create a better product. And it has claimed that it is not entering into any types of arrangements that in any way impede the competitive marketplace. So Google so far has taken the position that everything they do is fine.
Yeah, and also I think they say that very solid alternatives are just a few clicks away.
The competition is one click away, I think, is their statement.
All right, well, we're going to have to leave it there, but I will say to be continued. We're going to see what happens here, and I know a lot of folks will stay tuned, but thank you very much for sharing your insight. We really appreciate it.
Thanks very much.
When we come back, our spotlight on contributed content. Back in a moment.
Digital technology has transformed the way we live our lives. We can access any piece of information at any time from anywhere. We can share ideas with thousands of people instantly. Staying up to date with breaking news and events is easier now than ever before. All this lets us keep pace with the world in real time. Yet, have any of these innovations been applied to the way we research and practice law? Starting today, the answer is yes. Welcome to Bloomberg Law, the first and only real-time research system for the 21st century legal practice, created by the leading provider of data and information services. A single search feature with access to legal, news, and company databases provides you with powerful legal research results and a holistic view of your clients, filtered so you know the information you receive will be relevant every time. Customizable legal, financial, and news alerts keep you ahead of your clients and in tune with their world. An integrated workspace allows you to organize your results by client, by urgency, by topic, however you want it, and to share those results with people on your team. Log in now to experience Bloomberg Law.
Now it's time for our Spotlight on Contributed Content. This is a segment where we highlight an article that was featured in one of our Bloomberg Law reports. Today's article comes to us from Ian John, Alec Chang, and Neil Stoll of Skadden Arps. The title of the article is Federal Trade Commission Abandons Appeal of Laboratory Merger Challenge. The article examines the difficulties the FTC and DOJ have faced challenging mergers in the healthcare arena. And the authors focus on a recent FTC failure to preliminarily enjoin the merger of two clinical laboratory testing companies. This is a great article, and you can find it in today's issue of our Bloomberg Law Reports, Antitrust and Trade, on the terminal at ATLR Go or at BloombergLaw.com. Articles are contributed to us for publication by practitioners, law professors, and other legal experts. To find out more about how you can contribute, please visit BloombergLaw.com. A special thank you to the Skadden attorneys for that contributed piece. And again, our thanks to their colleague, who is also from Skadden Arps, Peter Greene. Bye, everybody.